with all, as they say, Mr. Chandler, with all due respect, most of us in our adult lives have been in a situation where you think, am I on a different planet? And that's, be very honest with you, sir, either you haven't kept up with what has gone on for 6 years, or it is the business model to ignore it. But this is a town that is as impacted as any other, where there is not uniformity in perception. I do have something that I've worked on for the last week and a half, and with your due consideration. Ladies and gentlemen, it is keenly instructive to remind ourselves how industrial wind came to the town of Cape Vincent. I will note up front that only those directly involved, from landowners to developer representatives, know exactly when the first contacts were made. You see, secrecy has always been a hallmark of the energy prospector's business model. For 10, 15, and perhaps more years, this township has been the target for wind development. What we have come to know with certainty is that through leases such as this, and I do have an original here, as this example dated July 26, 2010, the developers took license, aided by the lax nature of New York State real estate law, to legally bind a landowner to do the company's bidding. And I quote from section 8.4 entitled Requirements of Governmental Agencies. Owner shall assist, the owner is the landowner, shall assist and fully cooperate with grantee at no out-of-pocket expense to the owner in complying with or obtaining any land use permits and approvals, building permits, environmental impact reviews, such as seeker, or any other proposals required for financing, construction, installation, relocation, replacement, maintenance, operation, or removal of wind power facilities in the project. And this is interesting, it's in parentheses, whether located on the property, on an adjacent property, or elsewhere. My goodness, elsewhere. Including execution of applications for such approvals, if required. Further, in connection with any application for such approvals, owner agrees at grantee's request to support such applications, again at no out-of-pocket expense to the owner, at any administrative, judicial, or legislative level. Finally, and I'm almost done with this recitation, in the event that any laws, rules, regulations, or ordinances of any governmental agency provide for setbacks or otherwise restrict the location of any wind power facilities to be installed on the property or adjacent property, owner shall cooperate with grantee in obtaining waivers of such setbacks and shall execute any documents reasonably requested by grantee to evidence owner's waiver of such setbacks. Ladies and gentlemen, you will hear from others the issue of setbacks. That is, wind tower distances from residents, property lines, roads, and so forth. No wonder, given what I have read above, that BP and other developers claim, prior to Cape Vincent at least, such uniformity in siting criteria in currently operating wind farms in the state of New York. This lockstep tightness enforced through contract stipulations generates the basis for what BP interprets as the industry standard, and as Mr. Chandler said, the company standards. What is clear is the goal of targeted community through biased efforts of compensated and compromised local citizens. By the way, I did miss a point here, that there is no scientific justification embodied in the BP lease requirements. The Cape Vincent community at large gradually began to grasp the implications of industrial wind and the hold their leases held over landowners. In 2007, 2 town board members held wind leases, and another's close family held leases. The planning board chair held leases, and the board secretary was conflicted with leaseholding family ties. 2 wind developers were courting business here, and conflicted town officials paid loose attention to the town's code of ethics. Recusal from official involvement was considered appropriate, but only in the context of which company you were signed with. It didn't matter that the promotion of corporate wind's agenda was a conflict, no matter which developer applications your actions furthered. One was meant to complement the other. The ethical due diligence expected of elected and appointed officials was apparently secondary to the explicit expectations of leases and the potential for personal profit. At this point, you might ask, didn't anyone step forward to question this masking of ethical governance? Certainly. Privilege of the floor was allowed at town board meetings, but answers, let alone justifications for actions, were rare, but definitely tinged with emotion. Planning board protocol under the leaseholding chair was to deny most residents their right of speech. Beginning in 2008, the videotape records of these meetings substantiates the suppression of citizen speech. The actions of the suppression were characterized by vehemence that many residents withdrew from public interaction. One clearly remembers the visceral shock of this. Compromised behavior on the part of political leadership usually does not persist without support. Such support was given in writing by a sitting state senator and local land lease holder in 2006. This was bolstered in 2008 by an opinion from a staff attorney with the firm Whiteman, Osterman, and Hanna, who coincidentally had been hired by the town at the request of the leaseholding planning board chair. That law firm has a long history of pro-wind advocacy. I ask, what does the average listener conclude was happening? Big Wind's business model effectively separates the few with self-interest from the majority whose only expectation was and is for transparent, inclusive, and truly representative governance. Did anyone in the town of Cape Vincent, New York, complain? Yes, early and often to the State Attorney General's office. The record of this activity is robust and for all to see. After 6 years, the case against conflicted governance due to wind-related influence presumably remains open. Yet there has been no remedial action taken by the New York State Attorney General's office. It was interesting to note, however, that on August 19, 2009, a Mr. Michael Sakurada, VP for BP Wind Energy, did sign the governor's newly framed Code of Conduct Agreement. Local project manager Jim Madden signed the same pledge on June 30, 2009. Again, window dressing. There was no behavioral change on the part of either BP or local leaseholders in positions of power. I'm almost done. In 2011, the ballot box, the majority's last resort, led, and did so without a single illegality, to the changes that the state government was not willing to address. There are no longer conflicted leaseholding residents on the elected town board. Conflicting planning board members recuse themselves from wind-related issues. And now the ex-attorney general and current governor's actions seem directed at sacrificing Cape Vincent, New York to fulfill a goal for expanded energy availability. The evidence here lies in his resurrection of Article 10 legislation and rules. Link this with what appears to be his tacit acceptance of the BP tactical business model. Our home rule rights have been denied by an attorney general and governor who we once trusted. Mr. Chandler and Mr. Cuomo, let the discussion begin. You both know very well that alternatives to taking Cape Vincent do exist. That, you know, it really, there's no celebration for any of us. There's no celebration from the people who trusted what they were told individually in their homes. And, you know, there's no celebration for me. At one time, I was willing to do some negotiating. I can't now. This has just gone too far. And public outreach, you have to sincerely, sir, address what is really the division of this town. And if you're interested in just washing that, you're going to have a heck of a time with these next several months, because the past is with us. The issue of what went before with the prior planning board with seeker, I would defy anybody to tell me that due diligence was served. It was not. It was self-interest that was served. So as far as I'm concerned, you're starting all over. And what you claim in your PIP, you really need to rethink whether or not you are addressing this town all sides honestly, or if this is more of just the slickness, because there are some of us who've really been out in the world before. This is not the end of Appalachia, which one of BP's proponents did once call us. So that's that.